everyone. Thanks for joining. I would like to introduce the panelists. I'm going to keep it brief. We have Eileen Lehpamer, longtime crime reporter from News 12 Long Island.
Hello.
Anthony Tony Pinta, and Kevin Keating, defense attorneys, prominent defense attorneys on the island. Are you guys okay with me keeping those bios very short? We have a more extended version on our website. So big cases on the island. So I think, you know, a lot of us know each other here. I would like to keep this sort of a mix, right? Journalism 101 for reporters who perhaps like me don't cover court every day, right? 101, but also how Anthony and Kevin, you deal with the media, right? And Eileen can jump in on that too. So I have a slew of questions. I've spoken to my reporter colleagues over the last couple of weeks. So I'd like to start with this. Anthony, let's start with you.
Sure.
When you have a case, how do you think, what do you think is the best approach a reporter, how does a reporter best approach you, right? And how do you see, do you think it's a good thing to talk to reporters for your case? Or you know, we know you're fairly media friendly, right? But can you give us some tips, right, on what have you seen that you think has kind of turned you off a bit, or what is a better approach and how do we do it?
Let me start by saying that I think that the press is a very important player in the criminal justice system, right? No one talks of the press when we study criminal law or we speak of court processes. We speak of defense lawyers, prosecutors, and judges, right? Jurors. But the press, in my view, is really an important player because obviously the press is the conduit of information that's going to be shared with the general public, and everyone wants to have a favorable disposition with the general public, right? No one's goal is to be looked at negatively in the public. So I think the relationship between lawyer and journalist is a very important one. You know, we're kind of lucky here on Long Island for a lot of reasons. You know, there are certain people that cover certain regions for certain media outlets, and we develop relationships over the years. And I like to think that it's a good relationship. It's one of trust and respect and professionalism. So when we encounter each other, it's usually not for the first time, right? And we're dealing with our prior relationships and our prior experiences with one another. So I would say, getting back to your first question, when I get a call from someone in the press, and I don't recognize them, I'm very careful, right? The first thing I tell someone that I don't know is, I'm more than happy to speak to you about this. However, this is off the record. So I think the initial conversation between lawyer and reporter, for me, should be off the record. And for those of you that may not, those of you that are not involved in the press or deal with press matters, it basically means that it's a confidential communication. It's not going to be shared or made part of any press release of any sort. That gives me somewhat of a comfort level just to kind of understand who I'm dealing with a bit, kind of field some questions and get to know my landscape a bit. What I typically do, and many of you know this, is I speak off the record. I try to give the reporter necessary background so that when they're approaching the case, they have a good factual basis to either use what I have to offer in their story or develop their story, right? A lot of times I get an initial call when someone's starting a story, like Sandra, for example, does these long-term investigations, and she makes calls and in an investigative manner, not necessarily at that point a reporting manner. So, you know, and a lot of times your goodwill with defense lawyers could shed light on facts that you would never really ever come across. So personally, I'd like to understand who I'm dealing with. I'd like to understand what the goal is. And I try to deal with it initially off the record. When I do give a statement, I then do it in a very controlled manner when I first deal with someone, right? I'll tell you, get your email or your text, and I will text you my official statement. So there's no questions about the words I use and the context that I use them. So I think, again, to answer now your second question, is I think the best approach for a journalist to make upon calling a lawyer is, you know, introduce yourself, explain that, you know, I'm not necessarily looking for you to say anything in particular. Would you mind talking off the record at first? And I have a few questions to ask of you, and let the journalist then kind of, you know, take the conversation where he or she wants to take it. and then the lawyer will kind of provide whatever information that is necessary to help it along the way. But I think it's a symbiotic relationship where, you know, it could really benefit both parties over, you know, over a stretch of time.
And Kevin, for you, you know, obviously you represented Mangano, and, you know, I was there every day when I was with FiOS asking you questions as you were coming out of the courtroom, even I think during the lunch break too. How do you approach us?
Well, part of what I would say would simply be a repeat of what Tony said. Just to back up a little bit, I agree that the role of the press for defense attorneys is vitally important in our defense of big cases, because it doesn't begin with us. It begins with them. In every big case, the district attorney issues a press release. They start it. They start this process. They issue a press release, and district attorneys and U.S. attorneys are on Twitter. So every time there is a big case, the district attorney or the U.S. attorney, they issue a Twitter statement. They issue a press release. They go before the cameras and they give their view of the case. And they talk about the critical importance of bringing this prosecution and the importance of making sure that victims are represented and all of that. And then the news comes out with their stories, of course, and the news correctly interviews victims and they interview neighbors. So there is, from the defense perspective, typically in these big cases, there is an onslaught of press at the start of a case, which is the other side of the coin. Sometimes, of course, we represent innocent people. Not always, but sometimes we do. So therein lies the role of the press for us, people like Tony and myself. How do we correctly and ethically use the press to try to get out the other side of the coin? And it is an uphill battle oftentimes because of what I've said, the onslaught of press for days following a big arrest, and now with the passage of time, trying to get out the other side of the story. It's made hard also because defense counsel also deals with the reality that while we want to talk about our case, oftentimes there are things we don't want to talk about and don't want to bring out because we don't want to reveal it. So that's sort of the big picture dichotomy that we deal with in dealing with the press, trying to get our story out there, our truthful story, not revealing too much, and trying to put out the other side of the coin. So dealing with individual members of the press, and Tony said this, but from my perspective, it's one word, it's trust. Trust, and it's a two-way street. Trust. If I say to someone, look, I'd like this to be off the record, and I know with a particular person, it is off the record, I will give as much time as I can to a member of the press to give background, to help them out, to talk about a motion that I have filed, to go through details that they either don't have the time to go through, or perhaps it's a highly technical issue, whatever it might be. Because I know if I'm saying off the record, it's off the record. And I also know if I want to get a statement out to that reporter, a correct statement, that reporter is going to work with me. So it's all about trust.
So Eileen, thank you, Kevin. How do you, so let's say, Eileen, you're sent on a story, you're in the courtroom, you don't know the players. How do you approach, you know, a family, an attorney? Take it from, you know, our perspective.
All right. So I was going to weigh in a little bit on what Kevin and Tony said. Yeah, obviously we know each other for a very long time. I've been covering courts here for a very long time, and we have a relationship of trust. So that, I think, is obviously the most important thing, whether you're covering courts or anything as a journalist, right? You have to develop relationships with people and then keep your word. And when somebody says to you off the record, you are actually supposed to respond off the record before it's officially off the record. Although I don't know how many people still keep to that, but both parties have to agree to that. And, you know, I do like to hear you guys say, and I know you're very good with the press, that it is vitally important for a defense attorney, because I've actually had to sort of explain that to some defense attorneys who aren't often on the big cases. And I say to them, listen, as Kevin said, we already have the district attorney's comments, the police had a news conference, we've probably been to the neighborhood, but all before the arraignment even happens. So some defense attorneys that I've dealt with sort of think, well, if I just don't talk, you won't have as good of a story or as much of a story. But that's absolutely not true. We just have less about your client. And for the very reticent defense attorneys, sometimes I will say to them, look, I mean, I know you don't want to say anything on the record before you've had the whole time to know what your case is going to be, because then you don't want that used against you later in court, right? That you made statements to the press about X, Y, and Z. But you could always say something about your client. You know, he's lived on Long Island for, 20 years, or he has a family, or this is, just almost like something about their personality, to paint them in a better light. And I know, but both of you guys have done that before. But and then to answer your other question about like, how do you approach if you don't know who it is, right? So
how do you make them comfortable, hoping they'll speak to you, right? Because that's hard. It's difficult because not everyone's comfortable, especially with TV, going on camera, right? It might sometimes may be easier for print, maybe not, it depends. But, I think it's a struggle getting somebody who you don't know to agree to especially go on camera. Right.
So, in pre-COVID times when we would actually go to the courtrooms, as the press can sit in the front right behind the attorneys. So that is your best opportunity while you're waiting for a case to sort of feel out who's going to have the case. And, you could also always ask court officers, who is representing this person? They always know. You can also check webcrims or e-courts. Sometimes it's listed there, although that usually takes a little while. Sometimes the district attorney's office will tell you who is representing the person. And then if you don't know, and none of the court officers know, we sit in that row behind the defense attorneys. Tony, I've seen you there a lot of times in normal times, in Central Islip. And I just introduce myself quietly. And I ask, hi, I'm Eileen from News 12. Do you happen to represent so-and-so? And, and you just
better than having to chase them,
right.
After. Yeah.
Because, so then I always try to identify myself in the courtroom, tell them that I'm there. And then I ask, are you going to speak afterwards? I've definitely been told no. And then I said, well, we're here with a camera anyway. So you can either walk out and we'll just get video of you, but we are going to try to approach you anyway.
Yeah.
And the defense attorneys I've told that to, I think appreciate it, because nobody wants to be ambushed, right? So I'm giving you a heads up that we're there. We're going to record this anyway in the hallway, and you can either choose to speak or not.
So for Kevin or Anthony, I'm curious if there's something in press coverage, not to say that we do get things wrong, but is there something that you wish reporters knew that you perhaps think they could have done better? Can you maybe give us an example or something maybe we, as a whole, or certain reporters, maybe you wish they knew, had a better understanding of something when it pertained to the law?
Pertains to the law. Well,
or just in coverage, is there something you think it needs to be better understood?
Well, look, I think what Kevin said before, it's really a timing issue. By the time you get to the defense lawyer, you guys have been given a lot of information. You know more about the case than we do. And a lot of times what makes me feel a bit uneasy is when I'm dealing with a reporter who knows a lot more about the case than I do. And if I'm going to be asked a question that I don't really know about, or facts that are not terribly good for a defendant, how do I react to it, right? So, but I get it. You don't want to have every question and answer prepared. So I would think the best approach to take that I'd feel more comfortable with is let the lawyer talk. What does the lawyer want to say about the case first? And then just in terms of developing a good rapport and a comfort level, then maybe take a question, from that lawyer's statement, if it's factual. You don't want to just come across a lawyer and broadside him with the worst set of facts that he doesn't even know about, because then that really puts the lawyer at a really awkward situation in front of a live camera sometimes that just is potentially disastrous.
Kevin, your thoughts on cameras in the courtroom? It's very rare these days, at least in my time as a reporter, that we are allowed. And what I've experienced, and Eileen, I think you would agree, is that one particular judge that comes to mind does actually let cameras in the courtroom, but never with audio. So we have to zip the audio and we can just get the shot, not of the judge, of the defendant and the attorney. Thoughts on cameras in the courtroom and how it perhaps impacts your case?
Well, I think it depends on the type of proceeding, and my view about cameras during an adversarial proceeding, like a trial or a hearing. I think therein lies the problem, and particularly with a trial, because a witness on the stand, the slightest misstep by a single witness in a 20-witness trial, the slightest misstep can turn a trial. It just can. And what happens when there are cameras in the courtroom, witnesses fidget, witnesses get nervous, lawyers grandstand, some judges grandstand. It changes the tenor of the proceeding, in my view, during an adversarial proceeding. And when there's something as important as a trial and somebody's liberty at stake, I think that's the problem generally with cameras in the courtroom in that type of proceeding. In terms of other proceedings, such as an arraignment or a guilty plea is what it is. A guilty plea is it's a prepared text. Everybody knows what's going to happen in that event, and cameras at that proceeding will not impact the proceeding.
But what about an arraignment the original the arraignment right after the arrest?
Well, part of me says I wish cameras wouldn't be there, because you have a defendant, and sometimes a defendant, again, some defendants are innocent, and you put cameras in the courtroom and you have a defendant there on camera and he's being arraigned in this quite public event. And the unfairness of it, if you have one of those clients, and we do, the unfairness is paramount. However, I don't know that that's as big a concern as it used to be, frankly, because the press is everywhere otherwise, and Google and all of that. So once you're arrested and charged, you're charged in perpetuity because of Google. So cameras at an arraignment, personally, I'm not bothered by that. Cameras at a guilty plea, not bothered by it. Cameras at a sentencing, depending on the sentencing. And of course, depending on the victim at issue, who might have concerns for a variety of reasons with cameras being there. But in those proceedings, I think it's fine and oftentimes appropriate, quite frankly.
If I could just
trial and adversarial proceeding, I have my concerns.
If I could just intervene, I'm Keith. I'm a cameraman for Telemundo for NBC. I'm a cameraman in court proceedings, and being a camera in there, you're just transferring like information out of the courtroom to the general public, and you're just showing them what's going on and what not to do. And I think that's contradictory of what I work for. I'm just transferring information out of the courtroom to people in the general public. So I get what you're saying, but that's my take on it.
Keith, I agree with you. I agree, and I think there's a role for cameras in the courtroom, because it is just as you said. But if it has a chance of impacting the outcome of that proceeding, and I think that chance does exist in trials, personally, that's my view for the reasons I've said. But otherwise, I agree.
Eileen, what is your thought on what kind of a difference does it make to our story, right? Because we need the visuals, and court stories can be so difficult for TV in particular, and radio, right? And when you do get that camera in, which is a rarity, it's gold for us, right?
Right. I mean, so there's two things there. Obviously, the justice system doesn't care about making my job easier, and I understand that. But for me, what happens in the courtroom is supposed to be public, and that's my pet peeve. It's public. It's a public courtroom. Any member of the public can show up at any time. Anything that happens in a courtroom, there's a public record. There's court documents. When stuff is entered into evidence, it's also public. So I do understand from Kevin's point of view about how you don't want people grandstanding, because we've definitely seen that at nationally televised trials. But I would like, to me, a compromise would be, if I was in charge of everything, would be to have a camera placed in the courtroom that's not so visible. So not necessarily one of our media cameras coming in on big sticks, but if you just have it almost like a little surveillance camera, and it should be able to be viewed by the public. I strongly believe in that.
And which is interesting now because in these COVID eras, right, where we can't always get in the courtroom, now we're being sent links and we can watch this and
right. We can watch it, but we're not allowed to
record it.
Which is, you know, obviously this is a new development in the last year, but yeah, we can watch it, but we're not supposed to record it or rebroadcast it as a member of the established media.
All right, so I have a bunch of questions. I have a whole list, but what I'd like to do quickly, because this is also billed as Journalism 101. So Anthony, real quick, right? Federal court versus, you know, you're in criminal court in Mineola or you're in federal court. Why is someone tried in federal court versus being tried in, you know, Central Islip or in Mineola?
Sure. So there's different bodies of law that apply. You know, state court, district court, criminal court are all cases that violate New York State penal law. Usually, it's the more popular body of law that's prosecuted is the penal law. And when it comes to federal law, there's a whole body of federal criminal laws that apply. There are far, far fewer federal cases than there are state cases, primarily because most of the state cases are what I would term street crime offenses, where you have a crime that takes place, you have a police intervention and arrest, right? It's almost, let's say, a spontaneous type of thing, like a DWI or an armed robbery. Federal cases, to the contrary, are more long-term investigation cases that involve usually multi-defendants. So there are fewer cases in numbers, but usually more significant cases when it comes to the type of crime, the sophistication of the crime, and the number of defendants charged. Now, there are also individual cases brought. You know, they're not always multi-defendant cases, but it has to do with the body of law that applies and typically the facts. Sometimes you have cases that have, you know, dual jurisdiction, right? Like, let's say, for example, a narcotics distribution charge involving multi-defendants. It could be brought under penal law, New York State penal law. It could also be brought under United States Code. And sometimes you have joint investigations involving the feds and the state local authorities that work together and bring cases in both jurisdictions together. So very different jurisdictions, in my view. You know, the more popular, more in numbers are clearly the state charges.
Kevin, something I wonder all the time is, like, you know, often at arraignments you hear, you know, the arraignment, and I'm not talking about, I'm just talking about the initial arraignment after someone's arrested. The lawyer comes in, clearly doesn't know the client yet, you know, and most of the time you hear the lawyer at arraignment court saying, you know, I plead not guilty for, you know, my client pleads not guilty, but sometimes you don't. Do you have to say that, or do you not?
You don't, but typically you don't hear it in state court when somebody is charged with a felony complaint, because in fact you can't plead guilty to a felony complaint. So that's where undoubtedly, Cecilia, you typically do not hear those magic words said. Go before a judge, it's an arraignment on a felony complaint. If you go before a judge on a misdemeanor, you plead not guilty. When somebody's arraigned on an indictment, you enter a plea of not guilty. But when you're arraigned on a felony complaint, because you can't plead guilty to that complaint as a matter of law, you have to be indicted, or it gets rather technical. It can be converted into an information. But that document, that piece of paper, a felony complaint, does not allow for a guilty plea. And that's why oftentimes you don't hear it said.
It's interesting, Eileen, you probably understand, but at my last job, my bosses always wanted me to say he pleaded not guilty, right? But they didn't always say not guilty. And I would have to, you know, I was a reporter at FiOS, and sometimes I said, but I didn't hear them say it. And I didn't know how to approach that. So Eileen, if you're in court and you don't actually hear them say that, and the defense attorney doesn't talk, what do you do?
Well, I was going to say, so first of all, as you know, in court, oftentimes you can't even hear. So it's possible it could have been said, especially in in First District Court in Hempstead, which is at normal pre-COVID times, is a very large room, and there's so much noise you could almost not hear. But oftentimes I wouldn't even, I mean, no one ever pleads guilty on an initial arraignment charge. It's just, it's right. I mean, it's not even possible. It's not allowed. So it's just a natural assumption that it's a not guilty. So, you know, and then I can, if I can't hear that, I can call the attorney after and just say, you know, obviously your client is moving forward with a presumption of innocence, because that is the, you know, innocent before proven guilty. So I almost never really get too hung up in that, because the presumption is innocent until proven guilty.
Okay, so one thing that we kind of mentioned just now, and a friend of ours brought up to me was, and this is a major pet peeve of mine, and Eileen, you touched on this, is the microphones in the court. We can't hear half the time. And I can't tell you how many times I've been covering the trials in federal court are good. It's more state court, where you're at an arraignment and the court officers are chatting, the door is slamming, the microphone isn't on, and we can't hear a darn thing. And as you know, for those of you who don't cover court, the reporters often, even if they're competitors, we have to huddle and compare notes outside to make sure we got it right. So I'm curious, Kevin or Anthony, do you think something needs to be changed with, I mean, don't we have the right to have a proper audio system so we can hear what's going on?
Yeah, of course. And you said it, in certain courthouses, the courtrooms are equipped with proper audio, but I couldn't agree more with you. And I've seen you guys huddling in corners with your notes, trying to put together, did you hear this? Did you hear that? So yes, of course, it's one of the many problems with the system, one of the structural problems with the system. And not just for the media, it's for everybody else in the audience, for the victims, for the family members of the accused, for the family members of the victims, who are oftentimes piled into the courtrooms, desperate to hear what's going on. And depending on the courtroom, they hear nothing. Yeah. So it's ridiculous. And of course, I agree, it should be corrected.
Yeah, I'll just weigh in on that. So back to my other point about, maybe I personally think courthouses should have cameras installed that are a little more subtle. I think they should also have microphones that they can be broadcast in the courtroom. It's not that complicated. You know, that there could be a speaker even in the back, not that loud. And the proceedings could be recorded. I mean, now in COVID times, we've been able to get the link, and that link is often set up closer to near the judge's bench. And now I can actually hear things better through the links provided virtually. Yeah.
Okay, so Kevin, I think we lost Anthony for a second. I have a question for you. I could think of one case in particular that I would cover when I was at FiOS. It was a politician was in trouble and was arrested. It was in state court. It was in, where was it? I forget. It was in district court in Hempstead, and I would go, it would be adjourned. We would go back, it would be adjourned. Is that a tactic that defense attorneys use to just constantly adjourn a case? Can you talk about that?
Sure. So yes, not in every case, but it's a general rule that delay, generally, delay favors the defense. And the reason is, well, there are several reasons. One of them is, in a press case, frankly, you like to put distance between the initial press, which I talked about earlier, and the end of the case. Distance helps theoretically with a sentencing judge. Distance helps with prosecutors. You know, when a case starts, that prosecutor has maybe 100 cases, and this is a new case. And if it's a case of significance, it matters to that prosecutor. They're a human being. 6 months later, 9 months later, a year later, they have 100 other cases. And the case that mattered to them then perhaps matters a little less now. So in terms of negotiating a guilty plea and getting a good deal for your client, sometimes delay helps in that regard. Sometimes victims, quite frankly, with the passage of time in domestic violence cases, in the beginning of the case, they hold a certain view of the case. A year later, that view might change. And before the prosecutor is going to resolve that case, they're going to call the victim and say, hey, I'm thinking of offering, crime B off of crime A. How do you feel about it? The day after the arraignment, that victim would not go for that. A year later, they might, for a variety of reasons. So generally speaking, Cecilia, does delay help the defense? It does. Witnesses disappear. Police officers retire. There are a variety of reasons why delay is a helpful thing for the defense. That being said, oftentimes delays are not caused by the defense or controlled by the defense. Sometimes the delays, like you just said in district court, it could be a dozen different things resulting in that delay. Motion practice, the DA not turning over discovery in a timely fashion. That can go on for months. So There are delays built into the system for those reasons. And there are delays that, frankly, yes, the defense tries to create because it is generally a good strategy.
Anthony, you're back. Question for you. Bail reform, how has that changed your life as an attorney?
Well, it's made it easier for sure. I mean, preparing a case, and particularly when you are on trial and your client is in custody, is incredibly difficult. You have limited access to your client, and it really is a major impediment towards putting forward a good, solid defense. So it's made our lives a lot easier in terms of dealing with clients, in terms of access to clients. So it's all good on my end.
Eileen, COVID, things have changed for us covering stories. Can you just kind of tell everyone who isn't familiar with, there's obviously limitations. We can't get in the courtroom now because, there are only X amount of people allowed in.
Right. And I will say that I think all of the courts have gotten better about sharing the links to the proceedings, but especially in the beginning, it was obviously, like everything else, a whole new world. There were times when I actually had gotten a phone number of somebody who was working in the courts, and I would just call and they would put the phone up there so I could hear. Now they send out the links. So that's a positive for us, right? Because you can watch and listen and hear and do other things, because as you know, we're always doing 5 things at once. But there's also restrictions in the courthouses. So I was covering a case maybe 2 weeks ago where I got to the courtroom and I got in. It's a smaller courtroom in Central Islip, and I went and sat down. There was nobody else in there yet, but the court officers very nicely said, "Sorry, it's 10 people only." And I said, but there was nobody else in there. So I said, well, you have to have one member of the press because it is a public proceeding. You can't do that. And they said, okay, we're going to send you a web link. And I said, okay, like now? I need it now because, again, it's a public proceeding and it has to be witnessed by the public. So what ended up happening, I did leave. I was out in the hallway, didn't get the link. And then at one point then I was told I could come back in. And I guess they had conferred with the judge or something like that. So, but if that had been a situation where there were multiple members of the media who showed up, we would have had to agree, which we do, and we work well in Long Island, to be a pool reporter and maybe possibly a pool camera. But there's definitely no way in, like, as in normal times, all of us could get in the courtroom.
Eileen, and you just made me think of something pre-COVID, but Kevin, for, Ed Mangano, right, the trial, we hear there's a verdict. And what I've noticed, and I would be terrified to even go to the bathroom and leave the courtroom, because what happens is when you do have a high profile case, everybody who works in the building suddenly wants a seat in the courtroom. And I wonder what you think, Kevin or Anthony, about, do you think, there was a press row, but all these employees, whoever they were, are suddenly filing in and taking the press seats, and it got, at times, got ugly. Just wondering your thoughts, Kevin or Anthony, about, should the press, should there be a designated area at all times for the press, whatever the story may be?
I think there should be. That there's a designated area typically for law enforcement in the front row, as you know, of courthouses, and attorneys have a designated area. And the press, of course, is a critical part of all of this, has a vital role to play. And absolutely, there should be a designated area. And Cecilia, you're right. In big media cases, once the news comes out that there's going to be a verdict, it's sort of tradition that in that courthouse, all of the staff of whether it's the U.S. Attorney's Office or the DA's office, they all come flooding into the courtroom and they fill the seats. And the press that has been there for weeks, covering every single moment of the story, suddenly gets boxed out. So yes, there should be a designated section in every courthouse for the press. Totally agree.
And, a lot of times it's interns, and obviously we understand that people want to be in and see it, but I mean, our jobs are on the line. If we're not in there, Eileen, you would know, we're in trouble, right? Eileen, has that happened to you?
Yeah, I mean, so I will say that, again, on Long Island, the media is very good with each other. There's been times when, okay, you're sitting next to me, you have to go to the bathroom. You can leave your coat there and run and go get it. I think there was only one time in a federal courthouse where one of the U.S. Marshals said, no, I'm sorry, if you leave, you can't hold your spot.
Yeah.
And so you can't leave. But most times it doesn't happen. And I will say with bigger trials, as we saw right before COVID, there was an overflow room, which a monitor set up, and that really, really is helpful so that those people who work in the courthouse and come down for the verdict can at least watch it on the screen, hear it, and that was set up very well at the federal courthouse.
Anthony, can you explain briefly an Alford plea for those who may not know it?
Yeah, so an Alford plea is not typically done in these jurisdictions, Suffolk nor Nassau, only because of tradition. You see more of those, I think, in the city and in other jurisdictions. Basically, an Alford plea is a plea that you take without admitting guilt. It's basically the acceptance of criminal liability without what we would know as a particular allocution, like question and answer regarding date, time, place, and offense. So, I've tried to do that a number of times. It just facilitates things a bit. But in my experience, Kevin, I'm not sure about you, the DA's offices in both of these counties on Long Island, they don't do Alford pleas.
Yeah, Tony's right. It's policy dependent. The law allows for it. Some DA's offices will allow it in certain circumstances, and some offices never allow it. And my experience is the same as Tony's, that in Suffolk and Nassau, I've tried, but I've never had a case where they permitted an Alford plea.
Interesting. All right, I have to take questions soon, but Kevin, can we just talk about compassionate release? Can you explain what that is and what's been going on with that?
Sure, and that got a great deal of press, of course, during COVID. Actually, under the Trump administration, there was a change in the law under the First Step Act. And one of the changes enacted by that administration was the compassionate release statute. The statute had previously read that a sentenced prisoner, if they wanted to seek compassionate release, had to make application to the warden of the facility that the prisoner was in. The success rate on those applications, as you might imagine, was maybe 1%. The warden of a facility generally said no to an inmate for whatever the issue was. Let's say the inmate had done 26 years of a 30-year sentence, and he had diabetes, and his wife was ill, and that's the type of thing that lines up for compassionate release. So that if those applications were made to wardens, they were almost never approved. Under the First Step Act, one of the provisions was now if a warden denies the application, the inmate can go to the sentencing judge, go back to the district court judge to make the application. And the district court judges, particularly during COVID, as all of you wrote about and read about, were quite liberal with the compassionate release statute as it related to those who were in prisons, facing the heightened risk of contracting COVID, and those with pre-existing conditions who made them particularly susceptible to dire consequences. So a great many inmates were released under the compassionate release statute for those reasons, but I think they'll be continued to be released on a going forward basis for a variety of reasons, because district court judges, I think, are in a better position to analyze the case as a whole and render those decisions.
One more question, then I'll open it up. Access to court documents for reporters. Eileen, we know, I will start with you, Eileen. In Nassau County, after an arraignment, this is pre-COVID. I don't know how it is, well, because we're not at Hempstead, court anymore, because they're doing arraignments in Mineola, but it was great. You would go to the clerk, or I'm not even sure if that's you would go to the, right, Eileen, was it the clerk? The clerk.
Yeah, it would be in the courthouse there. They had access to all the documents.
And they would give you the complaint right then and there. Suffolk, I find, is a bit more difficult. I had to wait for 2 hours to get it. Case law documents, Eileen, how accessible is it? Is it difficult? Is it not for you to get documents when you're covering a story?
So talking pre-COVID again, like anything else, like I said at the start of all this, it's about the relationships. So you have to know who works in the courthouse, who will expedite your request. And we had certain people in, both in both courthouses that you would go to the window and they know who you are and you would, chat, and then they're giving you something that again is public access, right? It's a court document that was just presented. But yeah, if you don't have that relationship with the person who works there, they would print it, give it to the cashier. You would have to go and wait, and that could take up to sometimes an hour. So again, I say any of the journalists on here, relationships, you got to make sure you have them.
I'd like to open this up to, I still have more, but I would like to open this up to questions because I'm trying to keep it to an hour.
Before we move off the topic of documents, can I just ask the attorneys a question on that? Thank you. So I don't know if you guys would know the answer to this, but, you know, even after covering the courts, you know, for decades, it's still like a guessing game. Am I going to get just the felony complaint? Am I going to get the statements of witnesses? And then I only recently discovered that you could get the entire trial case file and sit in person and look at it. You can't take it out, but you can pull it and in the clerk's office, look at it in Nassau. Do you happen to know if you can do that in federal court too? Is it only after sentencing? Do you know when the entire case file becomes public? Certainly not during trial, I know that.
Yeah, so I'll chime in on that. So first off, Carolyn, traditionally in my experience, you guys get more of the paperwork than we do. You know how many times I've had cases where you have the witness statement, I just have the felony complaint. So it's certainly depending on a lot of different factors, numbers of copies, who the clerks are, et cetera, et cetera. In federal court, however, everything is docketed electronically. And if you have a PACER account, right, which is the network system that the federal courts use throughout the United States, you could access every docket of every criminal or civil case and print out everything that's there. Obviously,
during the trial as well, or only after the trial?
Well, you're talking about transcripts. Transcripts are going to be docketed, obviously, after the trial, after they've been certified by the court reporter and approved by the court. So you're never going to get a live feed of trial transcripts anywhere, in my experience, whether it's state court or federal court, unless you order a daily copy yourself. And I've had cases where the press has ordered daily copy, and you're entitled to it as well, just like the parties are or anyone. However, I have found the federal courts are real good in terms of gaining access to records. I just came on to a case in Maryland, a federal case in Maryland, and it was so breezy easy just to get all of the documents, all of the prior motions by just a couple clicks on the computer by this PACER program. But transcripts are a different story. They're going to be more difficult to get, and for obvious reasons.
And I know, Carolyn, like for transcripts, I think at federal court at least, you can go up to the court reporter and purchase it at the end of the day, but it's not cheap. I remember, Eileen, I don't know if you guys have ever purchased it, but I think when at my last job, I needed the transcript from something, and I think it was like $75 for the day. And my company, you know, it was when I was at FiOS, but it could be pricey.
It's cheap, actually. $75, that's actually really cheap.
Oh boy. Does anybody have any questions? I'd love to open it up. Thank you, Carolyn. Let's see what we have in the chat. Is this something the reporter should know? Usually everything is on the record unless notified beforehand.
Right. I think that's why I addressed earlier that
you did. Okay.
Technically, you both have to say off the record before you start talking. Otherwise, it's not an official off the record conversation. Not that I would do that to anyone that I have a long-standing relationship with, but it should always be noted. You say off the record, you wait for an affirmative.
I'm curious, Kevin or Anthony, do you ever feel that you've been burned by a reporter, and what can we learn from that?
Sure, I've been burned by reporters. Not often. It's a rare event. Nobody here, by the way. I'm looking at all the names, but yes, saying off the record and a reporter not honoring that, or writing something that I did not say, and a word or two, a different word can mean a lot. So yeah, it's happened. And I think, again, look, nobody's perfect. I'm not perfect. The reporters aren't perfect. It's just about trust and everybody trying to do the fair and ethical thing.
I'm curious, what about Anthony? Do you ever let your clients talk to us, or do you prefer to take the mic, and why?
Only after not guilty verdicts.
So Tony has never let a client. No, I'm kidding. It was a joke.
Typically not, because for obvious reasons. I mean, you don't want your client stating anything that could come back to cause a problem either at a trial or a hearing, or be used by a prosecutor to impeach him on a witness stand if he so testifies. I mean, look, we totally get the fact that each and every one of you salivate over having a criminal defendant give you an exclusive interview. Totally understand that. But there are really great reasons from our end not to do that. However, with that said, sometimes if I know there's going to be a guilty plea and there are certain facts that are undisputed, and it's safe to a degree where I have a comfort level, I've done it a few times on the cusp of a guilty plea, or on a sentencing. Very rarely, though, I must tell you. And I don't like doing it because it's just so perilous. It is.
Okay, I have a question here. We've seen a number of Brady-related issues in both Nassau and Suffolk in the last few years that have resulted in the resignations of prosecutors, new policy initiatives being instituted, et cetera. Curious on your thoughts, whether you see this as a systemic issue on Long Island, and whether you see the repeal of 50A as advantageous to the defense bar in building a case.
So on the Brady issue, do I think it's systemic on Long Island compared to other locations? I don't think Long Island is different than any other location in that regard. And I think prosecutors are human beings. We forget that sometimes. The fact that somebody's an ADA, and I was an ADA, and Tony was an ADA. The fact that somebody's an ADA doesn't mean they're ethical. It doesn't mean they tell the truth. It means they're supposed to. Most do. Not everyone does. The fact that somebody's an assistant U.S. attorney, it's the same thing. So is it a systemic here on Long Island? No, compared to other places. But is it a real life problem that is now coming to the fore? It is. And there are a number of cases. Cecilia, you brought it up. There are a number of cases right now addressing it. There's a very interesting federal case in the Southern District right now. I think it's Judge Nathan subpoenaed the emails of several assistant U.S. attorneys post-trial because the defense had made claims of Brady violations and withholding of evidence. And the emails were eye-opening. One email from one prosecutor to the other, I'm paraphrasing, but these are two assistant United States attorneys in the Southern District. One email said, I guess we have to turn it over, but let's bury it in whatever it was, thousands of other pages. So it's a real problem. I think efforts are underway to hold prosecutors' feet to the fire. The Brady obligations and disclosure rules have changed somewhat without getting too detailed to try to ensure that this doesn't happen, but it happens, and it happens to this day, and it continues to happen, and all of that.
The latter part of the question, do you see the repeal of 50A as advantageous to the defense in building cases?
Was it me or Tony?
Tony, I guess.
I do, clearly do, obviously, because that's going to open, potentially a ton of information that could be used to impeach a police officer, a detective, and traditionally, and we've all made these requests repeatedly on good faith basis. And we never win these in the past, but now we're going to be able to gain access to these records that could potentially be very impactful on cross-examination of these witnesses. Now, let me just say this, that, I could understand the outspokenness and criticism against it, because there's stuff in these personnel files that really have little to do with an officer's credibility, and it's exposing a whole lot potentially that isn't relative to an issue in the case. That's where you have a judge that should act as a gatekeeper, though, right? So in these cases, when you have personnel files under the repealed law, the judge is going to have an opportunity to go through that file, each and every page of that file, and determine the relevancy of each document and whether it's worthy to be disclosed to the defense or not. So you do have somewhat of a safeguard in place to protect confidential documents and irrelevant documents for privacy purposes as well. That, I think, is a very important part of all this, is the gatekeeping of a judge. And I'm for that, actually.
Eileen, something for you. You know, we have Kevin and Anthony here who tend to almost always, I think, talk to the media. How does it make your story? How much more difficult is your story in balancing your story when you have a defense attorney who just runs and won't go on camera?
Yeah, I mean, it definitely makes it a lot harder because then you only have the police version of events or the prosecutor version of events. And then your other choice is neighbors. And you can hope that maybe some, neighbor will know something and you hope it's accurate. But I think it does a huge disservice when a defense attorney will not even say anything on behalf of their client, because then we don't really have anything to put in a minute 30 television story about this person other than what we can maybe find, online, and then we would have to verify it. So sometimes, if you're really, really up against the clock and the defense won't say anything to you, you can look up what they do for a living, right? And then maybe you can mention that if you can verify it otherwise, like so-and-so has been a school teacher for 50 years. And this is, sometimes I will, if the defense won't tell me this, but they usually do, I will look to see or ask what the criminal record is, right? Because sometimes people don't have one, and that should be pointed out. Sometimes it's brought up in court at the arraignment, even if the defense attorneys don't say it afterwards. But I'm always a big proponent of, like you said, get out there and say something about your client.
Kevin or Anthony, I'm curious if you've ever had a cringeworthy moment where, the police walk, we call it a walk, right? Where someone's arrested and they're taken to court and we have that opportunity to get video. And occasionally, as Eileen knows, somebody will say, not necessarily I did it, but they'll say, oh, or I didn't mean it, or this or that. And they'll speak, right? Which is a rare moment for us, but obviously, that's something we use. Have you ever had a moment where you had a client say something and you're just kind of like, oh, yeah.
No. I have not.
Did both of you guys prep them ahead of time?
Luckily, no.
Nope. No. But
I've seen it. I've seen it on press reports, of course, and they're cringeworthy. But thankfully, it hasn't happened to me, and apparently not to Tony.
One question here: why would a case have a felony information instead of an indictment?
I saw that. Did they mean felony complaint instead?
Felony complaint, Brendan. I think you meant, right?
No, I think he meant information.
Oh,
sorry.
Okay.
Hi, I'm here. So yes, you mentioned a felony information before, and I actually just had that come up for the first time about 2 months ago. There was a federal case, and I don't deal with the federal courts too often, but there was a criminal case with a local person, and I reached out and I said, could I have a copy of the indictment, which is the thing that I always ask for. And they say, well, we don't have it yet, and it's not going to be an indictment. It's going to be a felony information, and it won't be available until after the court appearance, which ended up being over Zoom. And they explained to me a little bit about what a felony information is. And my impression was because the person was pleading guilty. Is that the only reason you would have a felony information instead of a indictment?
Tony?
Yeah, so look, I mean, we're talking federal court now. It's the same principle, right? So sometimes you could waive your right to an indictment. It's actually done quite often in state court. The Constitution of the state of New York requires felonies in order to be prosecuted to be presented to a grand jury. Sometimes you could work out a plea without a grand jury indictment. The vehicle for doing that is called a superior court information, and you plead guilty to that instead of an indictment. Now, in federal court, it's a same premise, different kind of nomenclature and terminology. You could be charged in a complaint, and you could take a plea of guilty upon an information, but the defendant has to openly waive his rights to a grand jury proceeding, because that's a right that you have to be indicted by a grand jury, right? The premise is that you have a group of people between 16 and 23 in numbers that hear evidence and decide whether, one, was there a crime committed, and two, was there some evidence that the accused committed the crime? It's designed to be a filter to kind of filter out the cases where there's literally no evidence or very, very, very weak evidence. So there are many advantages in proceeding without an indictment to prevent the prosecutor from having to do that work, seizing an opportunity, sometimes when you're representing a cooperator and taking a plea at an early phase of the case. So yes, it does happen. Yes, it happens, in my view, more in state court than it does in federal court. And there are vehicles in both courts to achieve that.
I'm going to wrap this up soon, but I have a question for Kevin or Anthony, or even Eileen, if you've seen this. So in federal court, right, there are sentencing guidelines. So, you know, someone's found guilty of X, and under the federal guidelines, it's 12 to 24 months or what have you. But it's completely up to the judge's discretion, right? It doesn't matter. Have you ever had, I'm curious, a judge sentence somebody like way more or way under the federal guidelines?
Yes, and let me give a little background, and I'll be brief on this. In the federal system, the structure is as follows. You have a statutory mandatory minimum and a maximum for every crime. Sometimes it's 0 to 20, for instance. Sometimes it's 5 to 40. And that means a judge must render a sentence within the statutory mandatory minimum and maximum. Then you have the guidelines. The guidelines formally, most people here probably know this, formally were mandatory. The guidelines is a point system, and depending on the nature of the crime and certain aggravating factors, points are assessed, and then there's a chart and a range of imprisonment. So if you have a 0 to 20, for instance, your range of imprisonment might be 48 to 54 months. Formally, the judge had to sentence you in there unless you were a cooperator, and other limited exceptions allowed a judge to go under it. Now the guidelines are advisory. So it's just one thing that the judge looks at. So have I had cases, and I'm certain Tony has had cases, where the guidelines, for instance, were 48 to 54, and a judge sentenced a client who was not a cooperator, because everybody understands that if you represent a cooperator in federal court, judges routinely depart downwardly in a significant way. But have I had non-cooperators who were sentenced below the advisory guidelines? Many. In fact, the national trend, I think, is that judges tend to impose non-guideline sentences in a favorable way. It is the rare case, although I've had it, and I suspect Tony has also. It's the rare case for a judge to go above the advisory guidelines in sentencing somebody.
Anthony, Tony?
Yeah, I agree with that. Far more cases where the sentences are below than they are above. There's a bit more involved if a judge sentences above a guideline range. If it's a plea agreement, you usually waive your rights to an appeal. But if a judge sentences above the guideline range, it allows the defendant to appeal that sentence. So there's good reasons why a judge will not exceed a guideline range when it comes to a plea agreement.
Eileen, did you want to add anything? I haven't gotten back to you in a bit.
No, I was just going to say, in state court one time, you know, I've covered a lot of cases, and one of the things that did surprise me one time was, I guess a sentencing deal had been worked out, and then it was the day of the sentencing, and whatever this defendant had said or done in the pre-sentencing report conflicted what was previously said, and the judge went crazy on him. And he got more than he should have gotten because he had told the pre-sentencing, in the pre-sentencing report, conflicting what he had previously said.
Well, can I just comment on that, Eileen?
Sure. It wasn't your case.
There's a lesson. Right. There's a lesson to be learned from that. And the lesson is you have to, as a defense lawyer, you must accompany your client to a probation interview. And in my view, failure to do so is legal malpractice, because having a client navigate that interview by himself is incredibly dangerous. And sometimes that exactly happens.
Right. But that was very rare. I can only remember one time where I was even caught off guard. I said, how? Yeah, I'm not sure who was representing it. Him, but.
It happens. I've seen it happen as well. Those are cringe moments.
Yes.
Yep.
Anthony, really quick, we kind of touched on this earlier, but you know, how do we best, do you have an example of a reporter approaching you in a way that you didn't like, and how do we learn from that? Because we didn't exactly give an example.
The way that I didn't like.
Or something that just rubbed you the wrong way, you know?
You know, you can't lead with, can I speak to your client? You know, it's just not going to happen. I think as I said to you before, and we really have a special environment here because, you know, it's a small community of lawyers and press people, particularly in the federal courts. It's a really small community of lawyers that do that kind of work. And we started off the session with these words, and we probably end with them, because I think that's the biggest takeaway from all this. It's all about respect and trust. It really, truly is. And, you know, when you have a reporter who is going to kind of maybe not allow you to kind of say what you want, or has in the past only taken part of your quote and didn't finish off the rest of it, and it's misleading. So the best advice I could give to journalists that are approaching criminal defense lawyers, just go easy at first, introduce yourself, explain the angle that you're trying to take on a story, because sometimes, reporters come up with these really terrific angles. They're not reporting for the first time. It's a follow-up story. And sometimes the angles that they take or the legal issues that they explore are actually quite fascinating. And oftentimes what I do is I say, you know what, let me look into this, because I want to be able to give you a good quote and help you. Let me research this issue. Let me look into these facts, and I'll get back to you. It's really okay sometimes when you're not operating on a deadline to say, you know what, you don't have to answer this now. If you want to get back to me with something, that's okay. I think that's a great idea if you're not operating on a deadline. If you are, then it's obviously a different scenario.
Right. All right, final question for Kevin and Tony. Do you go home and are you constantly looking at Channel 12 and Newsday and Channel 7 and Channel 2, or do you go home and you don't even want to see the coverage?
I go home and I look, and I suspect Tony does the same, because we're in the business. We want to see what new cases have been brought. We want to see who's representing the defendants. Why didn't I get that case? So yes.
Yeah, then I find out it's Kevin that has it. I'm like, ah.
But what about it, Kevin? What about it? I mean, if it's your case, are you like, you had a big trial. Were you looking every day, or were you getting home and you were just like, I'm done?
If it's my case, strangely enough, I probably look less, frankly.
Really?
Because it's been a long day. I'm done and all of that. But yes, we all look, we're all interested, and we all recognize, as Tony alluded to, I think we all have tough jobs. I think the press has an incredibly tough job for a million obvious reasons. And being a defense lawyer is not easy work. And that's why, as Tony alluded to, I think here on Long Island, frankly, the relationship with the press is great. I think generally there is mutual trust and recognition that we all have a hard job to do, and we're trying to make it easier on all of us. So.
Yeah. I just wanted to really quickly weigh in. Before I came to News 12 Long Island, I was reporting in the city for 1010 Wins, and it is nothing like this when you come out here with the relationships with the attorneys and everything else. And only once in Nassau County did an attorney tell me that he would be right back to talk to me, and he didn't. So guess what? I know who that is, and I remember it. And every time since, I let all the other crews know, don't trust him. He's not coming back.
Right.
So, it was something. And he actually went upstairs to the second floor of Hempstead and then waited. I'm like, what are you doing? So anyway, that's to say, bad. He burned the bridges, and that will never be forgotten. And it's known amongst the press corps. I'm not going to name names, but that's it.
Yep.
Well, guys, I want to thank everybody so much. I hope this helped. I hope it was interesting. Eileen, Kevin, Tony, you guys were great. I appreciate it. I hope it was enjoyable. And thanks, everyone.
Thank you.
Well, thanks, Cecilia. Thanks, Eileen. See you.
Thanks. Bye.
Bye. She was amazing.
Thanks, Charles.
Hopefully see you guys in court sometime soon.
Yeah.
In person.